So how do you make money in the patent world? The number one way is through patent licensing. Hello, my name is J.D. Hoovener, registered USPTO patent attorney, and I'm the managing partner here and CEO at Bold Patents Law Firm. Today, I want to dive in to help you better understand the number one way to monetize an invention, how to license a patent. Now, before we get started, I want to let you know that there are timestamps below in the details of this video where you can jump ahead to specific sections that you're looking for. I also wrote a detailed blog article that goes into this in a whole lot more depth on our website at boldip.com/blog. So let's get right to it. The first step to understanding patent licensing law and how to license a patent is understanding the underlying patent rights. Patent rights exist for utility patents, which is by far and away the most common in the claims. So understanding what you own depends on your level of understanding of what the scope of rights are. That is going to be clear as crystal in the claims. Now, if you're sort of shaking your head that clear as crystal isn't quite the case, you're probably going to want to rely on a trusted patent attorney to help understand what the scope of rights is. The second thing is doing the due diligence, really understanding and appreciating the difference of your invention from the prior art. Sure, you've got beautiful drawings and your specification talks about the glorious invention you've created, but truly, how different is it from what's already been done before? That's the scope and really the delta in what you're offering. On top of that, you've got to make sure that what you've got in terms of your granted patent is still going to be valid given today's laws. Patent law changes, as you probably hear in the news quite often, from Supreme Court decisions, Federal Circuit decisions, that actually will change the prospective rights you have. It's key to work with a patent attorney to know really how valuable is your invention and is it even still valid today? Okay, so the second big thing to think about is due diligence. Number 3, planning to make a solid deal. This is straight up negotiation strategy. When you're sitting down to the table with a prospective licensee, as the licensor, the one giving up rights, you've got to build a plan how this is going to go and have in place 2 specific things. 1, your goals. What would be a perfect deal for you, right? What is the optimal plan? What would you be smiling and doing a happy dance with coming out of that negotiation? Secondly, what are your walkaway terms? Okay, these are the terms that you're like, you know what? Deal breaker. I got to get at least 4% royalty, or I need this to be granted and exclusively termed. All right, well, if those are walkaway terms, you've got to hold to that. But it's so powerful to have those in hand coming into the meeting. It gives you posture, helps you really be a professional, helps you be not so emotional during that negotiation. All right, the next thing the first thing you talk about in the license contract is the grant clause. And I want to take a quick break here that, a license agreement is not just as simple as literally signing the patent over. This is a legal contract that you're creating with the other party. And it's a contract that should be binding on the entities and the individuals involved. So think of this as its own separate contract that you're creating. So back to what I'm talking about with the grant clause. The grant clause simply says what you're conveying. The grant is, in most cases, going to list the patent number, or numbers if you're granting more than one patent. What's interesting is that I've seen in some cases the ability to grant portions of a patent. Likely you've got more than one claim as part of your patent, and you can grant patent number 1, 2, 3, 4, 5, claim sets 1 through 10, and then separately license 11 through 20 in a separate transaction. It's got to be clear what's being granted. Secondly, who's it being licensed to? Obviously identifying the parties is important, but more importantly is the exclusivity. Are you licensing only to this other party? Or are they a non-exclusive licensee, meaning you're going to do the same deal with as many other parties as you can find? That's a huge price negotiation in terms of what the compensation will look like. Secondly, you got to understand and negotiate whether they're allowed to have sub-licensees. Oftentimes in transactions like this, they'll be required to find sub-tier suppliers or manufacturers downstream that may need to make and use this invention in order to bring it to market. Next is how long will it be licensed? The term. The term is key. People that I work with that are new to licenses think that the whole patent duration, right? The whole 20 years of patent life is what the term will be. And that's usually not the case. Both parties want to be able to come back to the table after some commercially reasonable time period so they can, make the best of the situation. Maybe the market's taken off and it loves the product and it really demands a higher royalty rate. Or, right, maybe the opposite is true and it's not doing so hot. The other party is going to want a way out of the contract. So the next one is, where will it be made, used, and sold? This is the geographic scope. And it's most important when you're negotiating a license contract that has international aspects. Let's say you have rights in North America, Canada, Mexico, and the United States. If you have rights in all three countries, you have the ability to license, let's say, one entity, one company, the ability to manufacture that, but they can make it only in Canada, right? And you're specifically telling them that they cannot in the US and Mexico. You can tell them they can sell it only in the US. So you can see these rights of who can make it, use it, and sell it can be split up among the whole world. So it can get complex pretty quick. Who enforces the patent rights? This should actually be negotiated. Remember, if you're the patent owner, you've got to remember there's no such thing as the patent police. They're not going to go out and enforce your patent rights for you. You've got to be proactive in finding out who is infringing on your patent. Now, what's neat is that when you license your invention to an exclusive licensee, they are also on the hook. Don't miss that. They're also helping you and required to help you if there's an infringer, a third party, because really you're putting all your eggs in one basket. It's a key negotiation term to make sure that they're going to be helping you with any potential litigation down the road. Last but not least, understanding when the license is going to be over. Termination clause. And it's okay. It's actually a smart thing to think about when a license should be terminated when you're on good terms, right? Make sure that all parties are understanding, hey, look, if this happens, if you breach the contract, if you don't send payment over in a certain amount of time, we will terminate, okay? So we've talked about a whole host of issues. I'm excited that you're going to be jumping into this adventure with us. The thing I want to help make sure you understand is a foundation, right? A good educational foundation is the best way to move forward. And the way I've done that is put that in a book format. I've written Bold Ideas, The Inventor's Guide to Patents, and I'm giving you a copy of it for free today. Go to our website at boldip.com/free to get your PDF download copy today. Have a great day, everybody. Go big, go bold.
Go big, go bold at boldip.com.